course, I welcome you to this live session. Today we're going to look at the laws of evidence. That is evidence 2 in Uganda. And where we are particularly going to look at documentary evidence. We're going to look at witnesses, that is examination of witnesses. And then we are also going to look at the concept of competence and compellability. We're going to look at the laws of evidence. With the laws of evidence, we are going to look at particularly documentary evidence. We are also going to look at examination of witnesses. We are going to look at also the concept of the competence and compellability of witnesses. And I think without wasting time, let me start. You are free to interact. You are free to interact as we proceed. So now I'm going to begin with documentary evidence. The question is, what is documentary evidence? The first thing to note is that documentary evidence actually is the first topic in evidence 2 that particularly talks about evidence. And I think for you that have done Islamic criminal law, I mean Islamic law of evidence, that is what we call Al-Kitaba. That is the Al-Kitaba. So we study documentary evidence in 2 or in semester 2. So what happens with documentary evidence? We begin by looking at what is a document. Before the revision of the Act, that is of the Evidence Act of Uganda, particularly section 2 of that act, it used to define a document. And basically anything, or in a simple term, anything on which information can be recorded is a document. Why? Because they had to look at situations where technology grows. And I think in the case of Slaudin versus Republic, you saw that even a tape recording was considered a document. So while defining a document, relying on section 3, section 2 of the Evidence Act of Uganda and various cases such as Slaudin versus Republic, you must be aware that anything on which information is capable of being stored amounts to a document. So after you've known that a document is basically something that can be used to store information and then capable of being exhibited. When I talk of exhibited, I mean this is a document that can be capable of being given in courts of law as pieces of evidence. So it can either be a paper, it can be a CD, it can be a tape recording, it can be anything so long as it is capable of storing information. So, documentary evidence, basically, that is any form of document that has been given in courts of law as evidence. So that is what we call the documentary evidence. Basically, any form of document or any document that, while arguing a particular matter, whether criminal or civil, and is given in as evidence, it becomes documentary evidence. Again, the same provision defines what documentary evidence is. Now, since we are dealing with how do we give in evidence, how do we tender in evidence when we are in courts of law? And one of the formats, last times while you were in your first semester, you looked at what we called confessions, admissions, expert opinion, all that, character evidence. Now, the other form of tendering evidence or giving out evidence is what we call documentary evidence. So how do we tender in? Now, we are going to see that in documentary evidence, we have to look at the different types of documents or the classifications of documents that we have in law. How do you classify them? And then the major reason as to why we want to know the different classifications of documents. That one takes us to how do we tender, how do we submit, what does the law talk about admissibility? Because here, for us to say that such and such is a document or such and such is evidence, it must be this that is capable of being accepted as evidence once tendered in courts of law. So we have to look at the classifications, know them, understand them, know whether they are admissible or not, when they are admissible or not admissible. So the first classification of document is what we call the attested versus unattested documents. Attested versus unattested documents. So the question would be, what is unattested document? What is unattested document? Or what is this document that requires attestation in law? Now, the first question would now be, what is attestation, or what is to attest? So to attest is to witness. You are going to see that there are documents that in law you cannot craft them, you cannot manufacture them, or you cannot generate them without someone else witnessing. We have seen affidavits, we have seen statutory declarations, we have seen deed polls, among others. We have seen wills. You have studied wills in your semester, in your year 2. We are seeing all those documents that they cannot pass the test of validity unless there is an independent person that has witnessed their crafting. So those are the documents that we call documents that require attestation. And if the Evidence Act has not been affected by the revision, previously attested documents were in section 67 of that act, that is of the Evidence Act. I don't know whether they have been affected, but previously it was section 67 of that act, that is the Evidence Act. So a document that requires attestation, that is a document that in law it does not pass the test of validity unless while it was being crafted or being manufactured, there was an independent person that witnessed. And a very live example is a will. You know what a will is. And when I talk of the will, I particularly refer to section 36 of the Succession Act, where that act tells us that, where a will has not been, that is the capacity of attesting, and actually section 36 and 50 of that act, that where a will is not attested, then it is not a valid will. So that is an example of a document that requires to be attested. So unattested document, of course, is the opposite of documents that require to be attested. Unattested document, that is a document that does not need to be witnessed by any person while it is being created or it is being manufactured. For example, if you are entering into a private agreement or a private arrangement between you and someone else. Thank you, Saddam Robert. You are welcome. So, if you are creating a document, an agreement between you and someone else, you understand? That agreement might not need to be witnessed by someone, so it becomes an attested document. So, but the attested document is one that it is a requirement of law. It will not pass the test of validity if it was not witnessed by someone else. So that is the first classification. Now, the second classification of documents is what we call the primary. No, before even I go to the primary, there is, sorry, someone was interrupting. Someone was interrupting. So what I was talking about was the issue of the private documents and the public documents. What is the distinction between the private and the public document? So, a public document is that document that a public document is that document that is available for public to scrutinize or to find. That is what we call a public document. And a public document is a document that can be accessed easily by whoever. That is what I will particularly call a public document. However, there is a classification of public documents in the Evidence Act. There is the way the Evidence Act tries to argue out that this is a public document and this is not a public document. But when you gather whatever the Evidence Act had to define of a public document, you'll find out that generally public documents are documents that are available to the public or that are accessible by the public. Basically, those are the public documents. And then the private documents are the documents that cannot be accessed by the public, but they are documents inter partes. These are documents inter partes, between parties, amongst parties. You enter into a private contract of sale of land. That is between you and someone. It is a private document. So, the question now would be, how do we access it? How do we submit it? We are going to see that. So we switch to the third classification of documents, and that is the primary documents as opposed to secondary documents. So, primary documents, in simple terms, you are going to look at section 60. That is of the previous act. I don't know with the new. That section will tell us that a primary document, basically these are, actually that section 60 tells us that there are primary and secondary documents. So basically it talks about the existence of both the primary and the secondary documents. Now, section 61 goes ahead to tell us that, you know what, primary documents, basically these are documents in their original format. So for primary documents, these are documents that are in their original format. And then for public documents, I mean secondary documents, these are documents that are not in their original format. In most times, they are the photocopies. Now, what I've been trying to shed is the distinction or the classification of these documents. But then, I have to talk about their admissibility in law. How do they admit this document? How do they admit the other document? So I'll begin with the general rule. The general rule of admissibility of documents was clearly introduced in the case of Omichand versus Baker. The case of Omichand, it is a locus. The case of Omichand versus Baker introduces the general rule regarding to admissibility of documents. It tells us that, you know what, while admitting documents, it is very important that let primary documents be admitted. I've just talked about primary documents being the original, that even if we have talked about the various documents that we have in law, where we saw the primary, the secondary, we saw the private, we saw the public, we saw those ones that require attestation and those that don't require attestation. Now we want to know, how does the law, or how do we admit these documents in law? So we begin with the documents, or the general rule regarding admissibility of documents. That general rule was clearly set in the case I've told you. That is the case of Omichand versus Baker. You just Google it, Omichand versus Baker. It will give you where it tells us that, you know what, while admitting evidence, it is always important that let us follow or let us allow primary evidence. So primary evidence is the best rule, or what we call the best evidence rule. You have always heard of that wherever you move, that tell us the best evidence rule. Now someone will tell you, but sir, we have never been taught the best evidence rule. No, it is very simple. The case of Omichand versus Baker comes up and tells us that, you know, the best evidence is primary evidence. So that is the general rule. Actually, also section 63 of the Evidence Act of Uganda, that is if it was not affected by the revised edition of 2024. Then section 63 also tells us that, you know what, the best evidence should always be primary evidence. That is the original format of the document. If it is not even tampered with, that is the best evidence. Now, we want to know the admissibility of the documents that we have seen in law. How do they admit them? So, the first way, or the first format, or the first document that we are going to look at is the document that requires attestation. Now here you are writing your paper. How do they admit a document that in law requires attestation? Remember, I told you that these are documents that in law require to be witnessed. So section 67 to section 70 of the Evidence Act clearly tells us the mode of attestation, of how we submit or we admit, what we call the admissibility of documents that require attestation. And actually, if I have to be specific, section 67 tells us that, you know what, If a document is one that requires to be witnessed, such as a will, for it to be valid on admission, there must be at least one attesting witness to give evidence. Meaning that if the document you are taking in law was a will or is a will, that will, if you are to tender it in as evidence or exhibits, it must be at least by one person that was there on its creation, because that is what section 67, that is if it was not tampered with by the revision, which tells us that there must be at least one attesting a witness. Then the question would be, what if the two attesting witnesses that we used are also not seen somewhere, we can't trace them, or they died? Won't this document be used as evidence? Then the answer again continues. You read section 68, section 69 to section 70. They will tell you clearly that now where the two witnesses cannot be found, then we can get someone that will come and testify the signature and handwriting. That you know what? They cannot be found, but this signature is for Stuart, and this handwriting is for Stuart. So in case there are no witnesses to testify, or the two attesting witnesses are not seen or cannot be seen anywhere, that's when now we are going to just acknowledge, or someone will come and validate that this is the signature and this is the handwriting of so and so. Then court will now admit that document as evidence. Now, another mode of admitting documents that require to be attested, I think this should be in section 69. This is where one of the testators, or sorry, of the attestators, the attesting witness comes out and says, you know what, I acknowledge this is my signature. Basically, he acknowledges the document. Then it will be tendered in as evidence. Then we should also know that all documents that don't require to be attested, of course, we go back to the best evidence rule under section 63 of that case of the Evidence Act, and the case of Omichad versus Baker, which clearly tells us that, you know what, we should always give evidence by virtue, or you should always prove your documents by submitting or presenting what we call the primary or the original document. So basically, that is documents that require to be attested and documents that don't require to be attested. I've told you with documents that don't require to be attested, for them you have to bring the best evidence, which is primary or the original. And then the documents that require to be attested, I told you, you must bring at least one attesting witness to prove. That is as per section 67 to 70 of the Evidence Act. Bring at least one attesting witness to testify. In the absence of at least one attesting witness, what do we do? Then let a person who knows the signature of the attesting witness who died or cannot be traced, or the handwriting of that person, come out and testify that, you know what, this is the signature, I know it, of this person. Then, or even the owner or the witness can come out and say, I adopt, these are my, basically he approves. Then all that, the document can be taken in or can be tendered in as evidence. Then now let's see, how do they admit the primary evidence and the secondary documents and the primary documents. Of course, for the primary, I've told you, you submit, we begin with the private and the public documents before we go to the primary and the secondary, because it cuts across. So the private documents, I told you, these are documents that are available to a person as a person. and I think they are in section 73, section 7374 of the Evidence Act. So the private documents, if they are to be tendered in as documents or as evidence in law, again we go back to the best evidence rule that was clearly set in section 63 and the case of Omichad versus Baker, which tells us that, you know what, the best evidence rule is primary, or it is the original. So even for private documents, if you have your will or if you have a tenants agreement or anything, you keep the original. Chebagamba, never give out the original, never serve the original. If you are to give someone your document, give them the soft, the what? The photocopy, retain the original. Why? Because it is not just a mere formality. No, it is a matter of law and a matter of principle under section 63 of the Evidence Act and the case of Omichad versus Baker, that while giving evidence or while admitting evidence documents that are private in nature, that is between you and a particular person, the best evidence or the best way shall be present the original. Now the document is, how do they admit or how do they submit or admit public documents? Because for private, we have seen, you know what, you just bring the original. But then, how do they give admissibility of a public document? Remember, I told you that a public document, this is a document that usually is available for the public to scrutinize, or this is documents that is available for public scrutiny. You can find it anywhere. That when you talk of the Constitution, you can Google and find it. When you talk of the Penal Code, you can always find it. So the question is, if you want to admit a provision of any of a document that is in public scrutiny, what do you have to do? How do you admit it? Sorry, how do you submit it? So here, it is very clear. It is very clear, and it is very, very clear that in situations of that kind or that nature, what you do, you always have to present a certified copy of that public document. You realize that as you come or you continue to develop in the spheres of law, you'll find that there are things that are required to be certified today. That, for example, a transcript, if you are to present the soft copy, I mean the photocopy of your transcript, it must be a certified one. And the person would be, or the question now would be, who certifies, or who does the certifying of the document? So the person who gives the document is the one that certifies it, to prove to whoever it is going to that this document he's giving you is a true copy of the original. So you cannot certify something that you don't know or you don't have. So if it is certifying that, for example, my transcript, I want to submit it somewhere, maybe I want a job, and they say we need certified copies, I cannot run to Makerere where I did not study from. No, I'll run to the institution that I studied from. It certifies. Why? Because it has to prove that, you know what, this is a photocopy, but you can accept it because it comes direct from the original. Why? Because the best evidence rule is primary evidence, or what we call original evidence. So now I've told you how they tender in primary and the secondary. Now, we have to look at the secondary evidence and the primary evidence. We are done with private and public documents. We are done with documents that require attestation and those that don't require attestation. Now let us see, how do they admit evidence that requires or that is secondary and those that is primary. Of course, for primary, I will not repeat myself. You have to give in the original. So they take the original. Then for the public, for the secondary documents or the secondary evidence, that is evidence that is not the original. So the question is, can it be tendered in as evidence? Can it be submitted as evidence? So you have to look at the situation. When do they allow photocopies? What are the situations when they allow photocopies? That is a situation that was clearly set out even in the Uganda Evidence Act. If it was not tampered with, that was section 64. That is a very important section, section 64 of the Evidence Act of Uganda. Very important section in a way that it tells us the situations when a document that is a soft copy can be tendered in as evidence. Look at that section. There are situations where maybe the original is destroyed, situations when the original cannot be found, situations like the original is in the custody or is in possession of the person you are fighting with and he cannot give it to you. So all of that are the situations or some of the situations in section 64 of the Evidence Act that tried to give us the situations when we can admit secondary evidence or soft photocopy or photocopied evidence. So that is the situation, or those are the situations under which in Ugandan law, particularly the Evidence Act, we tender in documents. If it is primary, original. If it is secondary, we can tender it in so long as it is a certified true copy of the original. Then we have seen if it is attested, present at least one attesting witness. If it is unattested, present the original. Why? Because section 63 and the rule in Omichan versus Baker, they tell us that the best evidence is that is original. And then the others just come in. Now, basically, that is what they want you to know when we talk of documentary evidence. I will not waste much time into the presumptions of documents. You have to read them. I will not go much into the presumptions in documents. You read them. I will not go much into the parole evidence rule because we don't have time. I need to tackle other concepts. But you particularly read section 92 of the Evidence Act if it was not tampered with by the so-called revision. Section 92 of that act, that is of the Evidence Act, it will tell you the parole evidence rule. Read from 92A, B, C, D, E, F. All those are rules and the exceptions. So they cannot tell you to discuss the parole and you don't talk about that section and its subsections. So now let's switch to the second concept of the laws of evidence 2 in Uganda, and we are going to look at what we call competence and compellability of witnesses. Competence and compellability of witnesses. For those that did the Islamic law or the Islamic laws of evidence, you studied about that concept of admissibility or competence and compellability of witnesses. But this is not Sharia law, this is secular law. So we are going to particularly concentrate on that concept regarding secular law. So Competence and compellability of witnesses. The question is, who is a witness? So a witness is a person that can be called to testify or to give evidence against a particular person. Now, why do we study the competence and compellability of witnesses? We want to know because, yes, they tell us that you can give evidence. But remember, in this world, we have different people who can see at a particular time. We have women and men. The question is, are women competent to testify in secular law? The answer is a what? A yes. But in Sharia law, what does it say? Regardless of the exceptions. So we have men. Are men competent? We have the young. Are the young competent to testify? We have the sick people. It might be someone who is sick, but it is him that has gotten chance to see or to witness. Will he be able? They are the drunk people. They are the insane people. They are the dumb people. So the question is, how do we tell that this person is competent? So basically, competence is the ability to testify in courts of law. Then compellability, this is the force that is used against someone should they fail to testify in courts of law. That's when now you realize that, you know what, being a witness is not prestigious. You cannot even brag that, you know what, I was a witness or I'm a witness, because it is an onus onto you that should you fail, then the compellability test applies in. So which competence basically is the capacity. Then compellability, this is the degree of force that comes into place where someone fails or refuses to testify in the courts of law. So we have to know what is competence and what is compellability. Which witness is competent and who is not competent? Who is competent and compellable? So we shall begin with the general rule in section 117. The general rule in section 117 of the Evidence Act is very clear that every person is competent to testify in courts of law, whether you are who, so long as you are able to make a distinct disposition about something, so long as you are able to tell what is right and wrong, every person under 117 is competent and compellable. However, you are going to see that yes, even if every person is competent and compellable, there are people with special characteristics that require special attention if evidence from them is to be obtained. So, the first witnesses that we shall talk about. So who are these witnesses? For example, you have over 3 witnesses, because we are going to see in the case of Mugo versus Republic, the famous case of Mugo versus Republic, it tells us that there is no particular number of witnesses required to win a case in Uganda or in law. Even one witness can win. That is in Mugo versus Republic. Actually, it was even retaliated in our section 133. I'm not sure, is it of the MCA or the EA, that is the Evidence Act. One witness can sustain. So, the question is, if you have witnesses of such nature, are they competent? And if competent, can they be forced or can they be punished should they fail to testify So the first witness would be a dumb witness. So a dumb witness under section 117 is competent. But the question is, who is a dumb witness? So a dumb witness is a witness that cannot speak. Does it mean that he cannot see? Does it mean that he did not hear? Does it mean that he cannot differentiate between the person who he saw? So the question is, should a person dumb see someone commit an offense, that person should not be punished because this person is dumb? No. So section 117 says that even a dumb witness is competent, actually, and comparable to testify. That should he refuse to testify, he can even be punished. So a dumb witness is both competent and comparable. But the mode in which a dumb witness gives evidence totally differs from the mode a person who is not dumb, that is a person who can speak, will give. That me who can speak, I will come out and say, Your Worship, I take oath, then I give all the evidence that I wanted to give, speaking. But for a dumb witness, he cannot speak. So the best way he can give evidence is by writing down on a piece of paper. So that is the key difference. But he is both competent and comparable. Now, the question is, what if it is an accomplice? It is an accomplice. You know an accomplice? Read section 132 of the EA, that is of the Evidence Act. So section 132 of the Evidence Act clearly tells us very well that, you know what? An accomplice witness, that is a witness that you have been convicted, you've been charged together. Me and you, we are on the same charge sheet. So the question is, can you testify? Can you testify against the other person? Are you competent? Are you compellable? So again, under section 117, and section 132, an accomplice witness or a witness of co-accused can testify. He is competent but is not compellable. That he is competent, that is if he wishes to testify against, but he cannot be forced to testify against the other. Why? Because he's not compellable. So an accomplice witness is competent to testify but not compellable. That is section 117. Read it hand in hand with 132 of the Evidence Act. So the other witness could be a child of tender age. A child of tender age. So the question is, who is a child of tender age? Who is a child of tender age? So the case of Arap Chibagenyi, there is a case of Arap Chibagenyi. Just look for that case. The famous Arap Chibagenyi case, Arap Chibagenyi versus Republic. He comes out and defines who a child of tender age is. Basically, they tell us that a child of tender age is one who is not above the year 14, is not above 14 years. So that is a child of tender age. So the question is now, can a child below 14 years testify or give evidence in law? So the answer is very clear, again in the case of Arap Chibagenyi, that a child of tender age can testify in law. However, again, he is competent but is not automatically competent. So they have to first determine whether this child is competent or is not competent. And how do we conduct the competence and compellability test to see if the child is competent? So we conduct what we call a voir dire. A voir dire. So before taking the evidence of a child of tender age, Arab Chibagenyi versus Republic tells us that, you know what, let a voir dire be conducted. So the purpose of a voir dire is to help establish if the child can understand the nature of the questions he's going to face, can understand, distinguish between right and wrong. So if court determines that the child is able to, that's when now the child will become competent to testify. So competence of a child of tender age is not automatic. It is not automatic. It is subject to court's analysis through a voir dire. So that's when court will conclude, tell us that, you know what, this child is competent to testify. However, a child might be competent if court finds them competent, but cannot be compelled to testify. Then the other witness that you can have is a spouse. You know things happen. So you would say, yeah, a spouse. Yes, today you are in love, tomorrow you are not. Today we are friends, tomorrow we are enemies. It is you who is going to stand and testify against me. So the question is, can a spouse testify against a spouse? Look at section 120. Look at section 120 of the Evidence Act. It will tell us who a spouse is. So a spouse basically is that one that is legally married. You have been or you have underwent marriage under any of the recognized types of marriages that we have in this country, Uganda, which we know it is civil, customary, Mohammedan, and Hindu. If you are married but not in those four that I've mentioned, then you are not a spouse. So the rule in Ara versus Amkeo, Rex versus Amkeo, the Rex Amkeo case tells us that no, a spouse cannot testify against a spouse. So if it is a matter that is involving a spouse, you cannot bring, or if the other spouse refuses to testify, you cannot force them. So in matters of a spouse appearing in court, the other spouse is not competent and not compellable. You cannot force a spouse to testify because they are not competent. They are not competent. Doctor, mbadde nkyaliko mu kazuuni. Naye yo doctor terisiivinga kubanga ya email zokka kanjikuwe naye yo terisiivinga bintu. kanjikuwe kati. Sorry. So we were still talking about the concept of a spouse, and I told you that a spouse cannot testify against the other spouse, and I told you that was the rule in Rex versus Amkeo, which clearly tells us that concept. However, you should also note that in civil cases, a spouse can be a competent witness against a spouse. In civil, but in criminal, no. In civil, yes. That is section 121 of the Evidence Act. You must have that act of head because it is a core. It cuts across all that you will meet. So, a spouse can be a competent witness in civil cases. Section 121, that is if the act was not tampered with or was not affected by revision. So, after you've looked at some of the witnesses that are competent and compellable, you also now have to look at the concept of privileges. Yes, we have seen the general rule telling us under section 117 that every person has a duty to testify, and shouldn't you can even be held accountable under the compellability test. Then now the question would be, are there people, but we have seen certain people who cannot be blamed, or are there people that can never be blamed should they fail to execute their duty of testifying? So that is when we have to look at the three types of privilege. The three types of privilege that we have in law of evidence. The first privilege is what we call the private privilege. The second one is what we call the public privilege. And then the third one is what we call the professional privilege. That these three privileges will help us or will assist us in knowing who obtains the privilege. A privilege is like something, is a benefit you enjoy for being something or for being someone. Kivaita privilege. So the question is, what are the three types of privilege? One, we have the private privilege. So that is a privilege that is enjoyed by certain people. And basically, in this character or in this category, we put the spouses under private privilege because of section 120 of the Evidence Act and the famous case of Rex versus Amkeo, which tells us that, a spouse cannot be held liable or cannot be competent and compellable to testify against a fellow spouse. So he now falls under the category of private privilege. Then the second type of privilege is what we call the professional privilege. So the professional privilege can be seen in section 125 of the Evidence Act if it was not tampered with. Section 125 of the Evidence Act. And that act will clearly tell us that, there are certain people or professionals that enjoy a privilege with that you cannot hold them accountable, or you cannot force them to testify against some people. And in the professionals, under Section 125, there are lawyers or advocates. You cannot force an advocate to talk about something relating to their client. A client gives me a case. You cannot force me as an advocate to testify, even if the client told me that, you know what, it is me that killed that one. I'm protected by Section 125 of the Evidence Act. Then also, still in the professional privilege, we see even judges. Under Section 119 of the same act. It protects judges. You cannot hold a judge accountable or a magistrate depending on what he decided or she decided in a particular matter. Actually, that is what we call the judicial immunity. They also have that. You can't force them. They are competent, but you cannot force them. Then the last privilege would be public privilege. Basically, this public privilege is enjoyed by people in government or people holding office in a particular government position. So these people, they enjoy what we call public privilege. And in the public privilege, when you clearly look at Section 122 and Section 123 of the Evidence Act, it will clearly tell you that people who are in government or people who are holding offices, you cannot force them to testify towards something relating to their office. For example, it can be security, army. You cannot force them to talk about, to release information that they see it will affect the public. So they are protected under Section 122 and Section 123 of the Evidence Act of Uganda. So those are the different privileges that we have in law. So there you will have fully executed the topic of competence and compellability of witnesses plus privileges. Then we now switch to the last one, which is witnesses. And with witnesses, we are going to look at the burden and standard of proof. The burden and standard of proof in evidence. Of course, the burden and standard of proof, I'm very much aware that it is not new in your ears. However, the burden is a duty, or it is an onus. And then the standard is the degree. Proof is to prove something. So what is the burden of proof? Basically, it is the duty onto someone to give evidence or to testify. The standard is the degree onto which this person should testify in order for maybe the state to sustain a conviction. So, the burden of proof, if we are to look at it, we have to look at it in both criminal and in civil. So in criminal, the burden was clearly laid in Wilmington versus DPP, and that is not a new case, that the burden of proof is on the prosecution. And then the standard of proof in criminal, again, was discussed in the very case of Wilmington versus DPP, that it is beyond reasonable doubt, leaving no scintilla or iota of doubt. So the standard is beyond, it is beyond reasonable doubt. Then, in civil cases, what is the burden? Who has the burden of proof? So you'll have to bring in principles of section 101, 102, 103 of the Evidence Act, which clearly tells us that in civil cases, the burden of proof is on to the plaintiff. The burden of proof is on to the plaintiff. And it is on the balance of probabilities. That is the standard of proof. It is on the balance of probabilities. So, that is the burden and the standard. However, there are situations where the burden of proof will shift from the prosecution to the accused person. Look at those situations. For example, in matters of diminished responsibility, insanity, those are all situations under which it can shift. So, since today is being the first day, you will permit me to put it or to leave it there. We meet next time. Thank you.